Hi, this is Jim Cunningham. In this video, we're going to talk about choosing your trustee and making sure they're properly trained. Hi, this is Jim Cunningham. We're going to talk about choosing and educating your successor, aka future trustee of your living trust. You got to do this right because there's a lot that can go wrong. But there has to be a better way of addressing the inevitable. You know, if you're watching this video, you might be watching it because you have a living trust. I mean, you might be the successor trustee for somebody else who has named you in their living trust. But really, is it really fair just to throw these trustees, these successor trustees, these people who are kind of like your executor, just throw them in the deep end of the pool without any training? That's what this video is about. And so we're going to highlight a lot of food for thought on this. We're going to cover a little bit of substance. It's a lot of, kind of who should you pick, right? I'm a partner at Cunningham Legal. I have over 25 years experience, and I think you stop at 25. We have offices throughout California. I'm a real estate broker, securities and insurance licensed, and a pilot, single engine land, so a fairly broad background. These are lawyers in our firm right now. Our law firm is dedicated to estate planning, and with that comes, we help out a lot of wealthier people and just, normal people as well. But a lot of our clients have a lot of real estate or stock portfolios, so we help them with that. And you can subscribe to our YouTube channel. Click the subscribe button. It'll pop up in your feed, and click the little bell, and you also get an alert. We have a live event workshop in our Sacramento office. So this is on Capitol Mall. That's where I am right now. Not too far, just a few blocks from the state capitol. That is April 27th. It will be live in person. And it's great because you get the opportunity to bypass our typical consultation fee, which is $495. So it's a really great opportunity. And we're going to be covering, is your estate plan up to date? Should it be reviewed? And it's great opportunity to meet in person. I will be presenting with a couple of other lawyers. So very important disclaimer. I'm a lawyer. I'm talking. This is not legal advice. A lot of this is ideas, but really seriously don't rely on this as legal advice, because this is really for informational and hopefully a little bit of entertainment value as well, but information only. So what is a living trust and what is a successor or a future trustee? A lot of people, I'm not going to spend a lot of time on this, but a living trust is like a bucket, right? And this is a bucket, and your document, when you write that living trust, that's the bucket. That's what we're talking about. It has a handle. You hold on to the handle. Typically, if this is your living trust, you're the current trustee, and you got the white knuckled holding on as trustee. And then when you stop being trustee, maybe you resign, maybe you become incapacitated, maybe you pass away, that bucket passes to the next trustee, which is called the successor trustee. So a little bit confusing. Successor trustee, when lawyers talk about it, it's the person who will serve after you if this is your living trust. And when you stop being trustee, that bucket hands over with all the stocks and bonds and houses and real estate and investments, all that in that bucket. We don't put IRAs, 401ks, annuities, and life insurance typically in there. Those stay out. We cover those separately, but that bucket passes to your successor trustee, and that successor trustee can do stuff with your stuff, right? And this really has two huge benefits. Having a living trust. If you have a living trust, the reason you did it probably is to avoid probate and also to maintain privacy. So probate, public proceeding, right? Anyone can see who your relatives are, what your assets were when you passed away, what your debts were, all public information. With the living trust, that stays private. And other benefits that come with the living trust, certainly in our firm, is we do talk about with our clients about protecting an inheritance from creditors, predators, and divorce. Now, this is after you pass away, right? Typically, and the people who inherit from you, we many times structure that in a way to protect from a future ex-son-in-law or future ex-daughter-in-law. That's what I'm talking about. Your kid inherits, and you probably don't want that going to the ex. I mean, you might if you like your ex, if you like your son-in-law or daughter-in-law more than your own kid. So what is a successor trustee? Okay. Hint, this is not you. Okay. This is when you're gone. You've departed this earth, and wherever you end up going, right? We can get metaphysical on it, but the idea here is you are no longer trustee. Now, there is a context where you are incapacitated. So if you're in mental decline and you need to pass that bucket off, slightly different rules, but a lot of the same principles apply. So there's just different nuances, and we can touch on that. So the successor trustee is the person named in the trust to manage, and the term lawyers use, and I'll put this in air quotes, is administer the trust. Horrible word. it doesn't even begin to describe people like trust administration. I have no idea what that means, right? So this is the trustee. I want you to think about this, is a human being with a heartbeat, meaning the person's alive. They're not dead, okay? That is a human being with a heartbeat who carries out the terms of the trust. So this is going to be an individual. So if you name your son or daughter as trustee, right, that human being would be the one signing the documents, is where I'm going with this. Even if you name an institution, a trust company or a trust bank, that institution will have a trust officer, which is a human being with a heartbeat, that will be signing and notarizing and dealing with things. So, you know, even if you name an institution, there's going to be a person attached to that, something very important to understand. Now, these responsibilities, what sort of responsibilities does the successor trustee have? Well, they have to follow the terms of the trust as written. Now, that may seem easier than it sounds, because a lot of this is written in legalese and a lot of trustees need help. The other issue is, what if somebody writes on their document? Now, if you have a living trust, you have to amend your trust in the manner provided in the trust instrument, the trust document itself. Writing on your trust, really bad idea. It's very confusing. We don't know who wrote on it. So just generally a really bad idea. So this is following the terms of the trust as written. The trustee has to manage the trust investments. And you typically, what the trustee does is they collect all the assets, right? And then they make an inventory of all the assets. And then they make distributions and they pay taxes and debts. And that's just kind of on a very high level what trustees do. Trustees also, not only do they have to follow the terms of the trust as written, this is really, really important. Trustees also have to follow statutes. They have to follow case law and something else called doctrine, which is not really case law, not really statutes. It is this sort of unwritten, you know, concept that the legal community comes up with. Unfortunately, much of the actions that a trustee has to take and the manner in which the trustee takes those actions, those are not written in the trust. So the trustee is going to be held accountable for stuff that's not baked into the trust, but it's law, it's case law, it's statutes, it's doctrine. So this is kind of where you need a lawyer's guidance on this. And that's what we typically recommend. At least, you know, one of the first things a trustee should do if you're named as trustee or you know, when that day comes, seek out competent legal advice. Half of our time during a given day in our firm collectively is spent on trust administration matters. So we're very well versed in this. The trustee also has to communicate with the beneficiaries. Now, that's a very fancy word for inheritor. A beneficiary, bene from Latin, the goods, the good, bene. Those are the people that get the goods. Those are the people that when somebody passes away, they get the stuff, okay? That's what we're talking about here. That's a beneficiary, also known as an inheritor. If you're a lawyer watching this, you'd say, Jim, that's not even a word, inheritor. But all the other normal people, well, all the other people who are normal people who aren't lawyers probably know what I'm talking about. So you have to communicate. That's very important. Here's a little bit of tip. What is the difference between a trustee or a beneficiary? Which one's better? You know, all things set aside, would you rather be a trustee or would you rather be a beneficiary? Well, I'd rather be a beneficiary. That means I'm getting stuff and I don't really have to do anything. If I'm a trustee, I get to do a whole bunch of stuff. And what do I get? Nothing. I mean, you might get fees as trustee. You might get an attaboy. But here's something to understand. Trustees have duties. Trustees have like a honey-do list, right? For the men out there and the women who might make a honey-do list, right? I get a honey-do list every third Saturday. Fix this. That's trustees have the honey-do list. They've got all these duties. Trustees have to do all these things. Beneficiaries, they can sit back. They don't have to do anything. They don't have to lift a finger. Beneficiaries can be total jerks, okay? Complete jerks. Trustees have to be the adult in the room, right? So, and also a beneficiary can take the trustee to court, kind of like sue a trustee. And that may not be a challenge. So, you know, a lot of people say, well, you know, if somebody challenges the trust, they should get nothing. And that's in a lot of our trusts. But something to understand is just because somebody files a court action, many times that's not considered a challenge to the trust, because the beneficiary says, well, I'm merely enforcing my rights as a beneficiary. I'm sitting on the couch in Hawaii waiting for my check, right? Trustee, do your job. So very important to understand, a lot of responsibilities with the trustee. So why is educating your successor trustee important? Why is it important? Here's why. And this is important perhaps before they become trustee, right? When you still have the power to put someone else in there as trustee. Trustees should, before they take on that role, fully understand their roles as well as their legal and ethical responsibilities and liabilities. And a hint on this is trustees are 100% personally liable for all the stuff that they do that goes wrong, that they should have done and didn't do, anything that goes bad in the trust. Trustees are, generally speaking, 100% personally liable, have to dig into their own pockets to make the trust and the beneficiaries whole. Trustees have what's called a fiduciary duty. Fiduciary comes from fides, the Latin fidelity, right? They have to act in the best interest of the trust beneficiaries, the people who are the inheritors. Remember that term, beneficiary means inheritor. That means that a trustee can't, they can't put their own interests before the interest of the beneficiary. They can't sell themselves stuff at a discount, right? That's self-dealing, right? That's, taking advantage. They shouldn't go to the ATM and take money out, right? All these things. And, this isn't necessarily in the trust, right? But this is part of that case law and statutes and doctrine. So following the terms of the trust, again, it's only part of the story. So somebody who says, hey, all I need to do is follow the terms of the trust. No, there's other stuff you have to do. And other stuff that's not mentioned in the trust, but this sort of case law and statutes require you to do. Trustee is responsible for managing the trust investments. Now, this is something that varies from trust to trust. Some trusts are very simple. If, Mrs. McGillicuddy's living in a rented senior apartment and it has $200,000 in her bank account when she passes away, and she's got one son that she's leaving everything to the son, that's different, right, than a more complicated estate. Okay, so it really varies. There's sort of the scope, and we'll talk a little bit about scope of what's going on. And again, the trustee and the trust must comply with all laws and regulations. So you can't opt out on a lot of this stuff. It's mandatory. Now, there is an exception to the 100% personal liability, and this was really important last year. Okay, remember the stock market went down? Horrible, right? Trustees are generally 100% personally liable for everything. If a stock goes down, the trustee potentially liable. 100% liable, okay? Now, however, if the trustee creates an investment policy statement or memorandum, and we do this for clients, and if you're a lawyer watching this, you'll be like, wait a minute, what? A lot of lawyers don't do this. This really does protect the trustee. You do it at the trust's expense, right? You take trust assets, you hire the relevant professionals, which is typically our firm, and we create an investment policy statement or memorandum. This can shield the trustee from liability. So this is very important. And, when the economy's going great and stocks are up, people are like, I don't need that. Really, it doesn't take that much time. We don't need that. We're just going to wing it. It's like, why would you do that? Right? Because you can have one beneficiary who's a crabapple, right? Who's a real pain in the neck, haul that trustee into court and say, I want the trustee to dig into the trustee's own pocket, own personal assets to, give me money. I'm the beneficiary sitting on a couch in Hawaii waiting for my check. Okay. So here's another reason why you're educating your trustee is so important. Trustees have to communicate with beneficiaries. So this may seem, I don't know, this may seem kind of weird, but trustees have to keep beneficiaries informed. It's just not some black box where, the trustee does a whole bunch of work and then gives the beneficiary a check. You can see why. It's like, wait a minute, what's the trustee doing? Okay, there's the house. Is it being listed? Is it being sold? What are the offers? Keeping in communication on varying levels, depending on the context of the trust administration, but keeping these beneficiaries informed. Trustees have the highest ethical standard, the fiduciary duty. There is no higher duty than a fiduciary duty. And the trustee must be mindful of conflicts of interest and avoid them if at all possible. So one example is a trustee, they might say, well, I'm trustee of the trust and no one wants to buy the house. I'll buy the house, right? I'm the trustee. That is a potential conflict of interest because you wouldn't want to get a good deal for yourself at the expense of the beneficiary. So that's an issue that we would have to address in the trust administration. And the trustee must stay current with the law. And I'm telling you, the law is always changing. Case law especially is always changing. So how these provisions are interpreted and how the law is applied in given situations, this stuff changes on a daily basis. And I would say this is a fairly dynamic area of law. Other areas of law, don't really change a whole lot. And what I'm talking specifically about is the administrative portion of the trust, not so much the documents themselves, but as issues come up, as these we can call them problems, as they come up, courts address these and new rules are coming out all the time. So why do people stop serving as trustee? Well, there are four main reasons people stop serving as trustee. One is death. kind of obvious. You have to be a human being with a heartbeat to be a trustee. And the other one is resignation. And resignation oftentimes is coupled with incapacity. So if a person has cognitive decline, many times we will have that person, if they have enough capacity, sign a resignation of trustee, and then the secondary person, so that successor trustee, steps into those shoes. And that would be, resignation. You're not totally incapacitated, but you're kind of in that twilight area. That's what I'm talking about. Removal is where a court removes a trustee or a trust protector removes a trustee. And we'll talk a little bit about a trust protector in a little bit. So each method triggers slightly different consequences. If the person is a trustee and not the sole beneficiary, there's a duty to account upon ceasing to act as trustee. So if you're the trustee, let's say your parents die, you're administering the trust, you're halfway through the trust administration, and you say, I'm done, I'm resigning, and the next person steps in as trustee, you, as the resigning trustee, have a duty to account. Now, I would suggest that you do the account before you actually resign, okay? Because you can use trust, typically trust assets for that. If you stop serving as trustee and then you find out you have to account, you may have to do that out of your own pocket, okay? So that's just a little bit of a mindfulness about trust administration. And sometimes these can get really ugly and really nasty really fast, depending on the family. Even if a trustee dies, there's still a duty to account. So let's say, mom and dad die and the son is administering the trust, and then the son dies and the daughter steps in as trustee, right? That estate still is going by the trustee's executor, has a duty to account. So very important. Let's talk about trustee ghosting. What am I talking about here? This is a reason to have a trust protector. So this is not an uncommon situation. And I hope if you're watching this video, you're not one of the kids who's a victim of this. So classic example, mom dies 8 years ago. Sonny, mom's son, becomes successor trustee. Sonny moves into mom's house, doesn't pay rent, keeps all the money in mom's trust, right? And stops communicating with his siblings, Abel and Baker. So we get a lot of calls like this from Abel and Baker. They say, hey, our brother's just ghosting us. He's just like not even answering our calls. Like, what the heck? We drive by the house, we see him there, he's watering the lawn, see his car parked there, we see him go to work, see him come home. He's still there. He's just not responding to anything, okay? Abel and Baker can file a lawsuit in probate court for removal of Sonny. Now, this is not a challenge to the trust, right? You're seeking Sonny's removal because he's not doing his job. For Sonny to account. So when mom died 8 years ago, Sonny has to account. What was in mom's estate when mom died? What's in there now? What's all the money that came in and what's all the money that went out? All those numbers have to add up. And surcharge for the value of living in the home and other trust money Sonny used, because I can guarantee you in this situation, Sonny should be paying rent to the trust, right? He has to treat, that's just not right for him to stay in the whole house and not pay rent, right? And exclude Abel and Baker. And also, I can tell you in situations like this, Sonny probably is using the money. He's probably using mom's money. So that's where you get a surcharge. Now, if he's used more than a third of the estate, Abel and Baker may end up with everything, and Sonny may end up, with a judgment where he's got to pay Abel and Baker. So it can get real ugly. This involves probate court, legal fees, court delays. It takes months, typically months and months and months and months to remove a trustee. Okay. There is a better way. If mom had a trust protector named in her trust, which is typically a trust protector, is a person who has power over the trust, but is not the trustee. So let me say this another way. The trustee has to follow the terms of the trust. The trust protector can remove the trustee. The trust protector can change certain provisions of the trust to carry out the intent of the trust. And we cover that in other videos. But this is really important. So having a trust protector, if Sonny's not doing his job, the trustee can remove Sonny, okay? And typically it's the threat of removal, and the trust protector would, call Sonny and say, Sonny, you need to go get a lawyer and get a good one, all right? Someone who knows what they're doing. Because if Sonny goes to any qualified trust and estates, or if Sonny came to us, we'd say, Sonny, you need to account, right? You need to do this. You can't just ghost your Abel and Baker. Let's talk about some minimum required successor trustee tasks. Now, I know it's a bit of a mouthful. These are the absolute minimum things, and it's an incomplete list, but I just want to give you, I want to answer, I'm anticipating answering a question. So sometimes people will go to an advisor, whoever it might be, and they say, you don't need to do that. Just follow the terms of the trust. Just write checks to everyone. What's the big deal? And we hear this from clients. And these are other professionals who aren't lawyers. They go, what's the big deal? All right. So here's if you're looking at serving as successor trustee, if you're watching this and you're like, okay, well, what's a minimum stuff I have to do? You should get multiple death certificates. You're going to need the death certificates. How many? I don't know. I mean, typically one per parcel of real property and maybe 3 or 4 more. So get a stack of them, right? Now, this is something that's kind of Captain Obvious. The trustee has to remove the prior trustee's name from all assets held in the trust, right? So remember that bucket analogy? If the trustee's holding onto the bucket, that bucket passes. Well, that's an analogy. That's figurative. That is not literal because there is no bucket, right? It's a document, and you have deeds. You've got bank statements with maybe the dead trustee's name on there. We need to remove that person's name. So that means typically with real estate, you create an affidavit of change of trustee and record that document. We used to, sometimes you can call it affidavit of death or affidavit of incapacity. Really, it's an affidavit of change of trustee. That's kind of the more modern approach. And you need to remove the trustee's name from the bank and investment accounts. How do you do that? You take the death certificate. That's why you need the death certificate. You go into the institution, you show them the documents. Okay, you sign some paperwork. Now your name's on the bank. So you're going to have to go there physically, right? And so, some online banks don't allow assets to be held in a trust. So it can be a little bit difficult. But really there's some mechanical work in there. And again, human being with a heartbeat showing up at an institution or notarizing these, having these documents acknowledged before a notary public. Then there's another sort of minimum, and this is really across the United States with, I think I found one state a few years ago, South Dakota, who did not have this requirement. Pretty much every state has the same requirement. California's is called the 16061.7 notice. I did not make up this name. It's a terrible name because we're referring to a probate code section. By the way, trust law is found in the probate code. And if you're wondering why I keep mentioning probate, it's because there's no trust code in California. It is the probate code, and the probate code has these trust provisions in it. So what is this 16061.7 notification? Within 60 days of the date of death, which is not long, the trustee must send a notification that includes the identity of the person who created the trust. Now, it's a settlor. It's what the statute says. It's also known as a grantor, trustor, or trust maker. The date the trust was signed, the trustee's name, address, and telephone number. Apparently not email. The trustees, the address of the physical location where the, quote, principal place of trust administration is located. What is that? That is the day-to-day activities of where the trust is being administered. Typically, the trustee's home or office. If you name a trustee in Texas to administer your California trust, the principal place of administration is Texas. If there is a problem with the trustee, the beneficiary very well may have to sue in Texas, not California. Okay. That beneficiary may have to sue in Texas. And I'm telling you, one thing you do not want is a Texas judge interpreting California law. I've seen a lot of bad results. Let me just put it that way. So typically not a good outcome. Any additional information that may be expressly required by the terms of the trust, and a statement that the recipient is entitled, upon reasonable request, to receive a true and complete copy of the terms of the trust. So you don't have to send the trust. You have to send this notice. They've got 4 months to challenge the trust. And if they ask for that trust, a copy of the trust on the 119th day, they've got 60 days, 60 more days to challenge the trust. So this has to be served within 60 days. And this is sent, who is this sent to? It's sent to everyone who would inherit in the absence of a trust. These are also called intestate heirs. So if you want to disinherit somebody, let's say you want to disinherit a kid, that kid is entitled to see the copy of the trust. Okay. That disinherited person has 4 months to file a lawsuit challenging the trust. It's also sent to everyone named in the trust and all amendments. So if you have a trust and 3 amendments, you have to send notice to everyone in the trust and the 3 amendments, even if somebody was in and then they were out by an amendment. A restatement is an amendment that does away with all prior terms of the trust. So it's not an amendment of the trust. It is a restatement. A restatement's like a big fat daddy. amendment to the trust that does away with all the prior terms. If you do a restatement, you do not have to notify the people in the prior trust or amendments that had been restated by this new trust. So stated another way, if you have a trust with a bunch of amendments, you might have to notify people that they were in and out, and people are like, wait a minute, I was named as trustee, now I'm out. I don't like that. If you do a restatement, they don't see that historical information in the 1606 1.7 process. Now it is discoverable in litigation, but they don't see it. They'd have to file a lawsuit to see it. Some other things, these are just real common things. Taxpayer identification number. Stop using the dead person's social security number, the person who's passed away, the decedent. You go get a form SS4, which is a federal form, and you get a taxpayer identification number for the trust. So I really wouldn't be using the decedent's social security number. If the decedent was a property owner in California, very, very important, the trustee must notify the county assessor within 150 days of death, because death is a change in ownership. So this is really important, especially in this new post Prop 19 era where properties are reassessed at death, right? There's really that parent to child reassessment exclusion pretty much gone. This used to not be a big deal. It really used to not be a big deal because the taxes didn't go up. But now you have 150 days is kind of a long time, right? Meaning that if you notify the assessor 150 days after death, that property will have been reassessed or will be reassessed as of the date of death. And if you don't make it within 150 days, there's a 10% penalty. So let's say in the case where mom died 8 years ago, and let's say, I mean, those penalties could be big, right? On the reassessed value. Now, if it's not a willful failure to file, whatever that means, there's a cap. The maximum penalty is $5,000 if there's a homeowner's exemption attached to the property, and $20,000 if there's no homeowner's exemption attached. So that's a maximum penalty, if not willful. And I'm not quite sure how you prove that up, but think about the properties you own or the properties you might be inheriting. What's the difference between the assessed value, what you're paying on taxes, and the market value? Sometimes these numbers are $20,000, $30,000, $40,000, $50,000 a year higher in taxes, and the penalty is 10% of that. So it can add up. If you wait years, it can be a really significant penalty. And they always get their money because it's real property. It's not going anywhere, right? It's kind of part of the earth. Get help, right? I mean, I would say if somebody is facing becoming a trustee, really one of the first calls they should make is to a qualified lawyer as soon as possible. And you really need to determine the scope of the trust administration. And I would tell you, this should be a paid consult. And, if you do a freebie consult, we've just gotten away from those in the legal profession since COVID. And I would say to expect to pay between $500 and $1,500 for the initial consult. It depends on the size of it. In our firm, we have, it's toward the lower end for the initial consult on the vast majority of cases, but sometimes it's only one meeting. And what do I mean by that? Well, sometimes, if a person passes away and all mom had was a $200,000 bank account and there's one beneficiary, there's really not a lot for a lawyer to do. But if dad passed away, mom's surviving, they've got 15 properties or whatever it is, and the ABC trust and the split, you're going to get lost. You're going to be in the woods pretty quick. So that's why it's important to reach out to the lawyer pretty much at the beginning. I would say that's the first thing you would want to do. And please do not solely rely on the advice from your CPA, financial advisor, real estate professional, inexperienced lawyer, or psychic. I don't know if you go see a psychic. Anyway, don't rely on those people, because there's a lot of bad advice out there. People say, you don't need to go to a lawyer. They're just going to charge you. They're going to overcharge you. There's no value. They're going to waste your money. Yeah, we can just get a form and do it and whatever. That's really bad advice, because think about it. You're the trustee. If something does go wrong, and stuff does go wrong, you're 100% liable. So you're the one who's going to be ending up holding the bag. Those people also don't have malpractice coverage, right? They're giving legal advice. They're not covered. One advantage of hiring a lawyer is if a lawyer gives you bad advice, sue the lawyer for malpractice, right? I mean, there's a reason why people hire lawyers. So I would not solely rely on the advice from these other professionals. And again, half of our firm's practice is helping successor trustees in administering trusts. So we're definitely have a larger practice in California, working individually with each person, but lots and lots of experience. So if you have any questions, you can reach out to us. If you're watching this on YouTube, you can call us. You can reach out to our our website. So let's talk about choosing the right successor trustee. Who is the right person? Remember, who's the right human with a heartbeat to do this job? You know, I think there are, in preparing the materials here, this is a really high level consideration. And I think these are considerations that everyone can understand. Number one, is the person you're considering competent to do the job? I would say professionals are what we call categorically competent. These are trust companies and trust banks. These are also private professional trustees. I would say that, you know, they have oversight, they've got regulation. I would put them as categorically competent, meaning they're going to get the job done, you know, unless they screw it up, right? With non-professional trustees, I would say results vary. Now, what about a non-licensed individual serving as trustee? In California, you can only do that for 3 trusts. If you can't do 4, right? So you can't just be, I'm going to be trustee for people. They have to be related to you. You know, and we'll talk about how that varies. Scope. You know, what is the scope of the project? Is it small or large? It's hard to discern if you're not used to looking at this, if the scope is large or small. And it is not necessarily correlated with size of an estate, okay? If somebody dies with $10 million in a bank and there's one beneficiary, pretty straightforward, right? I mean, there's a lot of money, it's pretty straightforward. But if there are people who are kind of, you know, already in the trustees here, like, hey, you know, I know mom died 2 days ago, but I really need some money. I really need an advance on my inheritance because, and then people are just in their ear constantly going after the trustee. I mean, that would be an indicator where you should probably get a lawyer, because you're going to need a lawyer to kind of help you navigate that, what you can and can't do. And then there's this concept of enrollment. And the closest analogy is, you know, it's like enrolling in school. You are emotionally present. So this type of labor is not physical labor. You know, when you're a trustee, when you're finished doing a work as a trustee at the day, you know, it's not like you're sore from getting, you know, if you're digging ditches, you're going to be kind of worn out and physically sore. So the type of labor that a trustee has is what we call emotional labor, which requires enrollment, meaning you have to be on board with doing this. You have to treat this as a real job. You can't just blow it off. Like remember the ghosting analogy, you can't blow this off. So I would say that you have to be prepared to be engaged, act professional, you know, don't get sucked down into the conflict that may be present with some of the beneficiaries. And that's what I mean by enrollment. So let's talk about the choices in professional trustee. You've got a trust company, which is typically a non-custodial institution. What does that mean? So a trust company can be like a big national bank. They might have a trust company. They might be selling investments, right? I mean, Wells Fargo would be an example. Wells Fargo has a bank, they have a trust company, and you can buy Wells Fargo mutual funds. Well, guess what kind of mutual funds that Wells Fargo is going to be, you know, selling their trust clients, right? The Wells Fargo mutual funds, right? And so there's a monetary incentive to do that. A trust company, that would be a trust bank. A trust company is non-custodial, and a lot of times we'll use Premier Trust in Nevada. I would really recommend that you kind of look at their website, Premier Trust, based in Nevada. They're non-custodial, meaning they're not selling investments. You can keep your own financial advisor. You can preserve those relationships, CPA, all that stuff. Typically, when you go to a trust bank, all of those relationships kind of end and the trust bank kind of gobbles it up. I'm not saying it's good or bad. My personal preference is a trust company. It's a little more responsive. Private professional trustee in California is a licensed designation, and you can Google private professional trustee and you can get a list of all the people, and it's typically done by county. That's a good method. I would say the downside to that is you're naming an individual person. You might also be naming their private professional trustee practice group in a sense. But many times, you know, you say, gee, I really like this person. Well, when it comes time for them to be trustee, that person may be retired because they may not be serving as trustee for a pretty long time. You can name a lawyer, CPA, and financial advisor. I'll put an asterisk on financial advisor. In our firm, we don't serve as trustee. California, you don't see a lot of lawyers serving as trustee. It's more of an East Coast thing. So if you're on the East Coast, yeah, I see that a lot in Boston, quite frankly. It seems to be the hot spot for lawyers serving as trustee. CPAs sometimes will serve as trustee. And then the financial advisor, if you say, gee, I really like my financial advisor at this institution, many times that institution will have a trust company. So the estate planning lawyer, our firm, would work with the financial advisor to make sure we have the appropriate designation. So that's why I put the asterisk. You're not naming the advisor himself or herself. You're naming that company that they typically name. And then there's the non-professional trustee, which is, the kids. We'll name the oldest to youngest. I don't know why. So a lot of people do. Is that good? I don't know. Blended family. So the Brady Bunch situation. It's where you've got, one representative from each family. And then a friend or other non-child would be a situation. Also the contextual, you need to think about, especially in the blended family context, if you've got one spouse has passed away or one spouse has passed away, then the other spouse becomes incapacitated. Does really the child of the deceased spouse really want to be involved taking care of, their mother-in-law or father-in-law or stepmother, stepfather? I don't know. This is where the counseling portion of law comes in, but it's just kind of food for thought. Another common question is 1 versus 2 trustees. When more than one trustee is serving at the same time, we call those people co-trustees. You could have 3 co-trustees, you could have 4, 5, and on and on and on. Some lawyers think that ever having 2 trustees is a terrible idea and should be avoided at all costs. I'm not in that camp. I think it can make it, functionally a little more clunky to have 2 trustees. If you have to have, especially if people aren't physically near each other. California, when we notarize a document, especially a deed, still has to be a piece of paper with a stamp. It's like it's the 1800s. We still have to do that in California. But I would say the risks in naming 2 trustees is disagreement. And what a disagreement does is it allows the one trustee who does not want to take an action to effectively have a veto, and it can create deadlock. It can also create litigation. So many times, if you go to court, many of those cases are 2 trustees fighting against each other. One wants to go left, the other one wants to go right, and they go to court to resolve their differences. 2 signatures are required on real property transactions. Typically, it's going to happen even if the trust says only one person needs to sign. Typically, a title company is going to require both signatures, but with banking, it's 1 signature. And the other thing is having a co-trustee subjects the trust to the taxation of the jurisdiction of the trustee's residence. There's a lot of legalese in there. What that means is if you're living in Nevada and you've got 2 kids and one's in Nevada and one's in California, you're going to subject your trust half of the income, because there's 1 trustee in California. This is crazy. Half the income is going to be subject to California income tax, income that's not distributed to you, a Nevada resident. Also, it's capital gains tax. Now, California has no capital gains tax. It's all income. So if there's a capital gain and that's not distributed, that can be a problem. So naming a trustee of another jurisdiction has its issues. What should a successor trustee know? Interesting. Where are the rules? Trustees have 100% personal liability for everything. The rules are in the probate code. There is no trust code. Different rules apply at incapacity. So if some assets are in an individual's name versus in trust for, meaning it's an ATF account, or it's a designation, a POD, a payable on death account, or other assets, there's an order of liquidation. So if you're the trustee of an incapacitated person, you need to draw down certain accounts before you draw down other ones. So this is like if a person has a joint account, a living trust account, an account in their own name, an account that says, when I die, this person that I've named gets the money. So there is an order of liquidation. By the way, the probate code is written by and for legal professionals, not for normal people. And you're probably a normal person watching this, and it's very confusing. The rules are arcane, cryptic, and sometimes counterintuitive. They go back to 1096 AD, the First Crusade. So they're almost 1,000 years old. And they're really, this is some of the oldest law in our sort of English American legal system. Some of the oldest law is trust law. I would say seek out competent legal advice. Absolutely not a do-it-yourself project. What should and shouldn't the trustee do? Or who should and shouldn't advise the trustee? Don't listen solely to the CPA, financial advisor, or non-expert lawyer. Do listen to a savvy, experienced lawyer. That's us, Cunningham Legal. That's what we do. There's just too much at stake. And if a successor trustee fails to seek expert advice, they are likely taking what we call excessive risk. Why wouldn't you just use trust funds to hire the lawyer to protect yourself as trustee? It's perfectly legitimate. In fact, the law encourages you to do that. Again, you risk being held accountable for every perceived failure. And this is really true. No good deed goes unpunished. The successes are largely ignored by the beneficiaries because that beneficiary is sitting on the couch in Hawaii is like, well, finally I get my check. There's really no thank you. And I think if you're a beneficiary, please thank your trustee because it is a thankless job and it's hard and there's a lot of risk. So successor trustee duties, what do they have to do? They have to act in the best interest of the beneficiaries. They can't put their interest before beneficiaries. They've got to file tax returns. Typically the last 1040, the last individual income tax return, and other income tax. A trust sometimes has to file frequently has to file an income tax return. Make distributions to the beneficiaries, manage the trust assets, keep accurate records, make regular accountings to the beneficiary. You have to account to these beneficiaries. You have to keep trust property separate from your property. So, if you're a trustee, don't just liquidate that. If mom dies and you're the trustee, don't just take all that money and put it in your own personal account. That's called commingling, right? That's a really bad idea. You have to keep trust property separate. You have to designate property as trust property. So this is typically going to be like personal property. You would want to put it in a box and label it, mom's dishes or whatever it is. Trustees have a duty to enforce trust claims. So if a trust is entitled to money or some other thing and defend actions against the trust, right? So if you've got a tenant not paying rent, you've got to, file an unlawful detainer, get that tenant out and get the property rented. You got to make it productive. Duty not to delegate, right? If you can reasonably personally perform these, you have to do it. You cannot delegate these activities. You've got to do it. And if there's two trustees, the one good trustee has to keep the other co-trustee from breaching the trust, right? Good luck with that. And if you have extra skill, you have to, if you happen to be a realtor, you have to use that realtor skills. If you're a realtor, maybe you're successor trustee for your parents, you've got to use that skill set as part of the trustees' duties. So what not to do, some really bad ideas. Not listening to your lawyer is probably number one. Borrowing or investing trust assets for your own benefit, right? Not protecting trust assets, not changing the locks. If that is a way of protecting the trust assets, paying yourself excessive trustee fees. How much is a reasonable trustee fee? Well, in Napa County, it's about 1% a year. In Ventura County, you got to track your time and bill hourly. So this varies county by county. Not only in California, California's its own thing. We have 58 counties, and so it's going to vary from county to county. And failing to prudently invest the trust assets, don't invest in a balloon party. Not a good idea. And not making distributions when you're supposed to. That's a big one. If somebody is entitled to a fixed dollar amount, I leave $10,000 to this person, and you don't pay that $10,000 within a year, that beneficiary, that person who's getting that $10,000 is entitled to interest on that $10,000. Okay. Probably going to come out of your pocket, trustee, right? If you should have written that check, if you just don't get around to it. Now, if there's no cash or other issues, there can be extenuating circumstances, but understand there are some time clocks on here. You have to get stuff done. And incurring penalties on tax returns. This is actually way more common than you would think. And it is a really, a relative of mine is a very large estate. They got a $2 million penalty because somebody filed something a few days late. So depending on the numbers, it can get pretty big. Record keeping and accounting. I think the trustees have to account to the beneficiaries. What does that mean? It means we started with this amount of money. This amount came in. This amount was spent on bills. This is what's left. All those numbers have to add up. That's what an accounting is. And the trustee is 100% personally liable for any shortfall. This is the way it is. Do yourself a favor. If you're the trustee, please don't withdraw cash from the trust checking account. Don't take the debit card, go up and take cash out. Every judge, every lawyer is going to assume that you're going to walk across the street and get pizza and beer and have a good time. Okay. That's just what everyone assumes when you take cash out. Really bad idea. I would also consider an interest-bearing checking account. Interest rates are going up. Probably a good idea. And really a separate checkbook and register for the trust account. So yeah, go ahead and order checks, I guess, right? I mean, who writes checks anymore? But typically you're going to need those checks and track them, right? And keep a ledger of what it was for and balance your checking account monthly and maintain careful records of all transactions because, depending on the case, depending on the context, you may be held accountable to a court. Tips for educating your successor trustees. Very important. How do you do this, right? Well, you can leave them instructions. You can work with a law firm who educates your successor trustee. That's a lot of what we do. So as the arc of the trust administration representation, it begins with essentially a letter of instruction to the trustee, meaning this is what's going on in your matter. This is, what you need to do. These are the next steps. This is what you need to pay attention to. And there is an element of training. We do sometimes have in-person seminars and reading. We have a lot of reading materials. And also our YouTube, if you're watching this on YouTube, we have a wealth of information on that. We also have family office services in our firm. So if you're a higher net worth individual, we can kind of train your trustee, if it's a family member, kind of over an arc of time rather than just when the event happens. You can draft custom language in your trust, saying the trustee shall attend educational programs, right? And do a lot of things to stay in touch. Now, this is probably if you're going to have a child as trustee, if you're concerned about that. And we've got on our website, I would encourage you to reach our website. We have a blog. We got lots of information, FAQs, and also on our YouTube page, we have a lot of content. And our book, Savvy Estate Planning, is focused on estate planning, not so much trust administration, but it is a good resource to understand estate planning just in general, conceptually. And if you're a lawyer or a beneficiary, this is really interesting. I would say use plain language. If you're a lawyer, be clear and concise in your instructions, okay? Don't use a bunch of legalese. Use plain language that the successor trustee can understand. Just, I hate to say dumb it down, but if your knowledge is a 10, it's not good enough to go down to a 6. You got to take it all the way down to a 1 so people understand, what are you telling me? It's like all this legalese and I'm stressed out. My mom just died 2 months ago and my brother's complaining. I can't handle it. Just tell me what to do, right? And provide the successor trustee with all the information that they need, and be patient, especially if you're a beneficiary. Please be patient. The successor trustee likely is unfamiliar with all of this stuff, right? And so be patient and answer questions they may have. They might need information from you. They might need your social security number. Now, if that freaks you out, there's a reason they're asking for that, right? Because they may have to provide that to an institution. And really thank the successor trustee for their service. Whether you're a beneficiary or a lawyer, it's a big responsibility. And it's always good to be thankful. It's very polite, and it does go a long way. And that brings us to the end of our materials. We do have a lot of questions. We have offices in Northern and Southern California. And next week, we have Rethink Your Retirement Planning Strategy. This is with Alyssa Kroger and Shannon Behan. Very important, kind of a lot of volatility in the market, up and down and up and down. And I know a lot of people are a little worried that they may have to delay their retirement. So just kind of rethinking your retirement strategy. Good content. If you're watching us on YouTube, please subscribe to our YouTube channel. And by the way, if you are watching this on YouTube, go ahead and just keep watching. The next video will just pop up in the feed.